Since 2014, one state alone has reclaimed over 3,000 acres of land in the Spratly Islands, turning submerged reefs into operational military bases. For decades, artificial offshore structures were limited in scale. They were isolated concrete platforms, like this sea fort, built for defensive or industrial tasks. Modern projects have reached a different order of magnitude. Mischief Reef now covers over 5 square kilometers, an area larger than some natural populated islands. The primary law governing these structures is UNCLOS, the UN Convention on the Law of the Sea. Specifically, Article 60 regulates how states build in the ocean. The convention is explicit about the limits of these structures. They do not generate a territorial sea of their own, and they cannot be used to redraw maritime boundaries or economic zones. While UNCLOS strips artificial islands of maritime rights, it contains a specific silence. The treaty never addresses whether the physical structure itself can be claimed as sovereign land territory. This creates a contradiction. International law defines exactly what happens in the water around an artificial structure, but it leaves the status of the land itself undefined. A state may have the right to operate a structure, but that is not the same as owning it. There is a legal distinction between exercising exclusive jurisdiction over a facility and holding sovereign title to the land it sits on. Under general international law, territory is not a physical object, it is a framework. It is the defined space where a state's public power is actually exercised. The traditional hurdle for artificial islands is a 1928 ruling by arbitrator Max Huber, which defined territory as a portion of the Earth's surface, a phrase historically used to exclude anything not naturally formed. But the naturally formed requirement has become a point of contention. States already use dredging and reclamation to expand their coastlines for airports and ports, and that new land is universally recognized as sovereign territory. If an artificial island is permanently occupied by a state and governed by its laws, it serves the same function as natural land. It becomes the space where that state's legal order exists. Because UNCLOS does not explicitly prohibit artificial islands from being territory, legal scholars are reassessing whether a permanent engineered landmass can be sovereign. Before we can apply territorial law, we have to categorize the physical architecture of these structures. First, bottom-based installations are made of non-natural materials, like steel, attached to the seafloor but not part of it. These are never territory. By contrast, true artificial islands are created by piling sand and rock onto a submerged reef until the landmass breaks the surface. While these look and function like land, international tribunals have recently struggled to classify them during territorial disputes. In the South China Sea arbitration, a tribunal was tasked with determining the status of Mischief Reef, a site of extensive reclamation and military construction. The judges employed what is known as the natural state doctrine. This rule dictates that a feature must be judged based on its condition before any human modification took place. This created a logical tension. The law classified a fully developed military base with an airstrip as if it were still a submerged rock. In its natural state, Mischief Reef was a low-tide elevation, a feature that is only visible at low tide and submerged when the water rises. Under standard UNCLS rules, a low-tide elevation that is far from a state's coast cannot be claimed as territory.
It has no sovereign status. The tribunal ruled that no amount of human modification could upgrade this reef. Even if a state builds a massive island, the law still views the feature as a submerged elevation. This logic ignores the current state of the geography. Evaluating a functional airstrip based only on rocks beneath it misses the fact that reclamation replaced the submerged reef with a persistent landmass. This fiction becomes even more difficult to maintain when considering climate change. If the law ignores when we create land, it might also be forced to ignore when natural islands sink and disappear. If international law clings to historical geographical states rather than acknowledging current physical reality, it risks becoming a useless fiction. To understand title acquisition, we use a geographical framework. Within the 12 nautical mile territorial sea, the state holds absolute sovereignty. New artificial land automatically belongs to them. The high seas are res communis. States can build islands, but UNCLOS forbids ownership. The middle ground is the EEZ. Unlike the high seas, an artificial island in the EEZ is created in an area legally susceptible to acquisition, a status known as res nullius. To claim title, a state must prove effective occupation. They must physically control the island and manage it through a continuous display of authority. The second requirement is acquiescence. If the international community does not persistently protest the occupation, the state's claim to the territory can eventually consolidate. This demonstrates that geography, not construction method, determines sovereignty. The zone where an island is built dictates whether legal title can ever be acquired. If we recognize artificial islands as territory, does that effectively reward states for expanding into contested waters? Critics argue that this would legitimize aggressive projects where states use dredging fleets to unilaterally seize control of entire reef systems. Many of these islands are built in direct violation of the law. For instance, when one state builds inside the exclusive economic zone of another without their consent. International law addresses this through the doctrine of unlawful territorial situations. This doctrine separates physical control from legal title. Just because a state has built an island and placed soldiers on it doesn't mean they have the legal right to claim it. An illegal act cannot produce a valid legal title. By treating these islands as territory, we don't validate the land grab. Instead, we bring them into a legal order where their status can be challenged and delegitimized. If an island is built in violation of international law, the occupying state is barred from acquiring legal title, no matter how permanent the buildings or runways might be. This triggers a regime of non-recognition. Other states are required to act as if the occupier has no legal authority to create rights or obligations on that land. This also applies to environmental standards. If a state destroys the surrounding marine ecosystem during construction, they risk forfeiting their right to claim valid title to the land they've built. This creates an incentive for states to follow international norms. If they want their artificial island to be legally recognized, they must build it in accordance with both maritime and environmental law. Abandoning the natural state fiction and integrating artificial islands into the territorial legal order establishes a framework to regulate how states occupy these engineered landmasses.